Jermaine Bay with Alonium Morris Pradium, Ante, Colorado. The acronym is AMPAC. I am Chief Judge of Consular Court. Today is Class 43. Class 43. What did we learn in Class 42? Well, we started learning that Moors are not Americans. But where did we get that reference point? We started really examining the treaties to see what the treaties say about Moors. And the Moors always mention the Moors in the treaties as being Moors, Moroccan, Moorish governments, sometimes Mohammedans, etc. But the treaties never refer to Moors as being Americans. The treaties never refer to Moors as being the Americans. Why? Because that would be an oxymoron to the contract. What contract? The treaty. The treaty has two parties as it relates to the bilateral treaties of peace and friendship, and that is who? Who are the parties? Moors and the Americans. It's that simple. So when Moors refer to themselves as Moorish Americans, if you call yourself by both parties of the contract, then that means you're conflating the two. What does conflating mean? Taking two truths and putting them together. So when we do that, what have we done as Moors? We just created a brand new third party. And that third party does not exist in the treaties. So therefore, we're operating outside of the contract, outside of the treaty, when we invent a brand new name that has nothing to do with the treaties. So how can you enforce a treaty under a brand of a Moorish American when there's no mention of Moorish Americans in the treaty? So Moors have to get back to what's called strict sense of liability of contracts. You must understand, contracts, Moors are studying what's called contract law right now. Contracts are very specific as it relates to strict liability. And the strict liability of a contract, the parties must be known. And according to our treaties as Moors, we're either Moors or Moroccans of Moorish governments. We must come back to a Moroccan government, not a Moroccan American government. It does not exist. So Moors must understand, if in fact we want to get our estates back, then we must come back to Morocco and choose between the entire submission of the laws of Morocco. It's as simple as that. So today we'll continue to keep talking about the French protectorate. We left off on that in class 41, so we'll pick up right where we left off, okay? Why are we learning about the French protectorate? Because I want to continue to impress upon the Moors that the United States of America and France are always talking about the Moors. What specifically are they saying about the Moors? They're always talking about your status. They're talking about you being a stateless Moor. They're talking about you being a protege. They're talking about you being a subject. They're talking about you being the property of the Americans. That must be understood, Moors. So let's keep studying what they're saying about us. And most importantly, what do we learn from this? How to enforce our treaties. We're learning how the United States of America likes to negotiate. They don't like to stick to the strict sense of treaties unless it benefits them. If it does not benefit them, then they ignore the treaties and they circumvent treaties, or they try to come up with a side contract that undermines treaties. And that's what Moors must understand. Stick to the strict sense of treaties. If we just maintain the fundamentals, we'll be all right as Moors. Let's continue. All right. So as I said, we'll open up with AMPAC's Constitution. So you can see AMPAC's Constitution is up here. Why is that important? Because AMPAC is following the basic instructions of what? The previous treaties of Moroccans. 1787, 1836, 1880, and 1906. Those four treaties, right? What are we talking about? You got the Treaty of Peace and Friendship, okay? Let's get ourselves together here. You got the Treaty of Peace and Friendship, okay, 1787. You got the Treaty of 1836. You got the Treaty of 1880. You got the Treaty of 1906. These are the four basic treaties. Why am I talking about these treaties? Because the United States of America thinks these treaties are important. France thinks these treaties are important. The ICJ thinks these treaties are important. So guess what? These treaties should be important to Moors. So let's go ahead and get started. All right, French Protectorate of 1913. Okay. So when we left off on the French Protectorate of 1913, we were in the process of reading about what the State Department of the United States of America was talking about. They were talking about Moors. Okay? They were talking about Moors. So we're going to scroll down and see exactly what they keep talking about that relates to Moors. So keep in mind, this is the United States of America talking, and then France will have a rebuttal to the United States, okay? Now, before we get started with the reading, let's take a look at the board, okay? Because these are very important titles that I have up here, okay? So first things first, we're going over what's called the 1913 French Protectorate in Morocco. You must understand the French Protectorate, which is called the French Zone, is an overlay over top of Moroccan's empire, okay? So what we're reading is about foreign relations in Morocco. That's why when you look at this document that we're reading, you'll keep seeing Morocco, foreign relations, etc. Right? The United States is now putting these titles on their own documents. They know they're talking about Morocco, okay? So what is the French Protectorate really about? It's about Moors branded as protégés and subjects. That's why they keep talking about the Moors. What is it really about? It's about the jurisdiction of consular courts. That's why France is coming over talking about consular courts and Moors continuously, okay? What else is the French Protectorate about? The estate, the Moorish estate. It's about land, deeds, and real estate. That's what French Protectorate is about. What else is it about? It's about trade and commerce and ports and customs in Morocco. So we keep learning about that, okay? Now, here's a question. Who are the parties being discussed in the French Protectorate? There's three parties constantly being discussed. The first party is France. And who is France? They're acting as a vice sultan. Who's the other party? The Americans. Who are the Americans? The citizens of the United States. That's who are the lawful Americans. Who else are the other parties they're talking about in the French Protectorate? They're talking about who? The protégés. Who are the protégés? Stateless Moors, which are subjects. Stateless Moors, which are subjects. So the protégés and the subjects is what they keep talking about and referring to in this document. Okay? So Moors must understand these are the people being discussed continuously in this document. All right? Let's get started.
Turning first to the subject of the revision of the protégés lists mentioned in Mr. Peretti's note of September 14, it is proper to state that the protection of native Moors in Morocco by this government rests upon its treaty with Morocco in 1836 and the Madrid Convention of 1880. The relevant party of the Treaty of 1836 is found in Article 5, which reads as follows.
Okay, let's stop right there. So, just as a refresher, who are the protégés? The protégés are the Moors, branded as protégés. What does protégé mean? You're the protected party. Why are you being protected as Moors? It's because you got ran out of your own governments. And now you are the protected party in America, in the United States of America. Because the columns are saying that the Empire of Morocco no longer exists. That the Moors, or what they call the western part of the empire, are not functioning their own governments. So if you don't have a government, then by definition, now you come under the government of the conquering party. That must be understood. So therefore, the United States, this is the United States talking. They're talking about who? Native Moors. They know exactly who you are, Moors. Let's continue.
Merchants of both countries shall employ only such interpreters and such other persons to assist them in their business as they shall think proper. The Convention of 1880 declares in Article 1 that the protection of native Moors is based on the British and Spanish treaties with Morocco and on the Convention of 1863 between France, Morocco, and other powers, with the modifications introduced by the present convention, and stipulates in Article 16 that the authorities of Morocco will recognize no protection of any kind whatever, save such as is expressly provided for in this convention. After a careful examination of the several articles of the Madrid Convention relative to the protection of American protégés, The department is unable to reach the conclusion that the Moorish government enjoys the right, ultimately, to decide upon the persons who may become proteges of this government.
Okay, let's stop right there. As a refresher, remember what I said. The Moors have been branded as proteges, okay? Proteges, hold up. The Moors have been branded as proteges, which means you're in the protected status of the Americans. You are the property of the Americans. There's no such thing as Moorish Americans. When you call yourself a Moorish American, you're saying that you're American. If you call yourself American, that means you're saying you're on the other side of the party. You're on the other side of the contract. You cannot enforce both sides of the contract by saying you're a party of both sides of the contract. Doesn't make sense. So therefore, the colonists appreciate it when Moors keep referring themselves as Americans. Because that means the Moors are admitting they're the proteges of America. Moors are not Americans, but we are the protected party of the Americans because we're their property until we do what? Enforce the treaties on ourselves. And we choose between the entire submission of the laws of the empire. What does that mean? Come back to Morocco and get out of America. Get out of the United States of America. That way you're no longer a protege of America. You're just a Moor. Let's continue.
On the contrary, Article 2 of the Convention provides that foreign representatives at the head of a legation may select their interpreters and employees from among the subjects of Morocco or others. And Article 3 provides that consular officers shall be allowed to select their employees.
Stop. Okay. Here's another reference point. Okay, right here. They're now referring to you now as what? Subjects of Morocco. Now referring to you as subjects of Morocco. You see, you are a what? Protege, and you are a subject, which means you're a what? Stateless Moor. That's what you are. Why? Because you got ran out of governments. So you can see they refer to you as subjects of Morocco. These are the names they use to brand you. Let's continue.
By Article 5 of the same convention, the government of Morocco recognized the right of ministers, chargés d'affaires, and other representatives, which is granted to them by treaties, to select the persons whom they employ. In regard to the list of protected persons, the convention is equally precise, as appears by Articles 7 and 8, which read as follows.
Okay, now we read this before. We're just being redundant, refreshing ourselves. Let's continue.
Article 7. Foreign representatives shall inform the Sultan's Minister of Foreign Affairs in writing of any selections of any employee made by them. They shall furnish annually to the said minister a list of the names of the persons protected by them or by their agents throughout the states of the Sultan of Morocco. This list shall be transmitted to the local authorities, who shall consider as persons enjoying protection only those whose names are contained therein.
Okay, hold up just a second. As a refresher, right here. This is 1880 when this was written. Article 7 of the Treaty of Madrid of 1880. And in 1880, what was happening? The Sultan had states. All states in Morocco are the property of the Sultan. Why? Because it's a part of the bilateral treaties. It's a part of the multilateral treaties in Morocco. So anything in the jurisdiction of the empire belongs to the property of Moroccans to oversee said treaties. So therefore Moors states, the Sultan now is who? Are Moorish states, because there's no more sultans. Who now takes the place of the Sultan? States, because it's about state rights. All right? That must be understood.
Consular officers shall transmit each year, Article 8. Consular officers shall transmit each year to the authorities of the district in which they reside a list bearing their seal of the persons protected by them. These authorities shall transmit it to the Minister of Foreign Affairs to the end that, if it be not conformable to the regulations, the representatives at Tangier may be informed of the fact. A consular officer shall be required to give immediate information of any changes that may have taken place among the persons protected by his consulate. Regarding the appointment...
Okay, just a moment. Okay, so what is Article 8 about? Article 8 is about a list of protected people that are on a list. That must be understood. That's the simplest way you must understand it. Who are the protected people? People branded as Negro, Black, Colored, and Indian, Puerto Rican, etc., 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 including people who call themselves African Americans, including people who call themselves Moorish Americans. Because if you call yourself a Moorish American, you're admitting that you're a protege of the United States. That's the truth. Let's continue.
Regarding the appointment of proteges for signal services, the Convention provides in Article 16 that the Minister of Foreign Affairs at Tangier shall be previously informed of the nature of the services and notified of the intention to award them in order that he may, if need be, present his observations thereon. Yet the final decision shall be reserved for the government to which the service shall have been rendered. Concerning the protection of the native employees of private persons, the Treaty of 1836 appears to contain no stipulation, but in Article 9 and 10 of the Convention of 1880, there are found the following provisions. Article 9, servants, farmers, and other native employees of native secretaries and interpreters shall not enjoy protection. The same shall be the case with Moorish employees or servants of foreign subjects.
Stop right there. What should we start understanding about Article 9? Why is the United States putting this out? They're saying that the Moors, who have been branded as protege subjects, Negro, Black, and Colored, Indian, African American, and now the new name is Moorish American, cannot come under the protections of Moorish governments whatsoever, because people have a right to what's called self-determination. What do I mean? When the Moors fail to come back to their own treaty rights, they have determined their own self-determination and continuously be United States citizens because they've been naturalized as citizens of the United States. So therefore, Moors can't be in a position where we start to tell the United States of America, those are our Moors. Because they're, what they call their coloreds, are entitled to their own self-determination. So the United States is pointing out that the United States has a right to put together the list, and that the French protectorate or the Moorish governments can't come in and say who should be on the list and who should not be on the list of the United States. That Moors themselves, through their self-determination, have to come back to Morocco on their own. And France nor Moors can say who gets to be on the list of the United States. You got to catch what they're saying, because France was saying, hey man, hey United States, where's the list? The United States says, well, you don't get to tell me who's on the list. But France at the time was trying to pick who was going to be on the United States list. That's why the United States is talking about this. They're saying, I get to pick who's on the list. France don't get to pick. Moorish governments don't get to pick to see who's on the list of the United States. You got to catch what I'm saying. But Moors can pick who's on the list of their own. We'll talk about that another day. Let's continue. Article 9.
The second paragraph. Nevertheless, the local authorities shall not arrest an employee or servant of a native officer in the service of a legation or consulate, or of a foreign subject or protected person, without having notified the authority upon which he is dependent. If a subject of Morocco in the service of a foreign subject shall kill or wound any person or violate his domicile, he shall be arrested immediately, with the diplomatic or consular authority under which he shall be notified without delay.
Okay, so these are just basic instructions, right? Then let's say France had a protege list, or United States of America had a protege list. If one of their proteges, i.e. one of their properties, one of their colors, does something wrong and infringes on the rights of some other foreign national, that foreign national now has to come back and petition the slave master or either the administrator of said protege. If they just can't come directly after the protege, they have to now come and talk to the administrator of that protege. That's what you need to understand. Let's continue.
Article 10. Nothing is changed with regard to the situation of brokers as established by the treaties and by the Convention of 1863, except what is stipulated relative to taxes in the following articles. Inasmuch as the Madrid Convention refers in Article 1 to the Convention of 1863 between France, Morocco, and other powers regarding the protection of native Moors, and to the British and Spanish treaties with Morocco on the same subject, it is appropriate to examine the provisions of these treaties on the subject.
Let's stop. What should Moors start learning immediately about this from the first time we started reading this in class 41 until up until this point right now in class 43? Who do they continuously keep talking about? Moors. The Moors are the golden goose. The Moors are the ones that are the descendants and successors of treaties and of the land, of the estate. So the best thing you could ever do as a power of attorney of someone who's rich is keep the rich person in a shallow grave. And that power of attorney lives off of that rich person's estate. That's why they keep talking about Moors, because the colonists, i.e. the citizens of the United States of America, more specifically the administrators, are living off of the Moors' estate because the Moors are in a shallow grave. They're in a coma and don't know who they are. And the Moors that do know who they are don't know how to make a proper claim to their own estate because they keep calling themselves Moorish Americans instead of simply just a Moor who has now chosen to come back to the entire submission of the laws of the empire. What does that mean? Coming back to statehood. Let's continue.
The provisions of the Convention of 1863 appear to be substantially the same as the regulation relative to protection adopted by common consent by the Legation of France and the government of Morocco, August 19, 1863, reprinted in Treaties in Force 1904 at the end of the Madrid Convention. The regulations are in part as follows. Protected persons are divided into two classes. The first class comprises natives employed by the legation and by the various French consular officers. The second class consists of native factors, brokers, or agents employed by French merchants for their business affairs. French protection is not extended to natives employed by French citizens in agricultural occupations. It is moreover understood that agricultural laborers, herdsmen, or other native peasants in the service of French citizens shall not be legally prosecuted without immediate information thereof being communicated to the competent consular officer in order that the latter may protect the interests of his countrymen.
Okay, let's continue.
The list of all protected persons shall be delivered by the proper consulate to the competent magistrate of the place, who shall likewise be informed of any changes that may subsequently be made in the said list. Each protected person shall be furnished with a card in French and in Arabic, mentioning his name and stating the services which secure this privilege to him. All these cards shall be issued by the Legation of France at Tangier.
Okay, so what's happening? France is making distinctions, and the United States is making distinction of who's on the protected parties list. And those protected parties have an identification that's issued to them by the state of France and the state of the United States of America. That's how they identify themselves, okay? They're classifying their property. That must be understood. Let's continue.
The British and Spanish treaties mentioned in Article 1 of the Madrid Convention are presumably the General Treaty of December 9, 1856, between Great Britain and Morocco, and the Treaty of Commerce and Navigation of November 20, 1861, between Spain and Morocco. In the British treaty, it is specifically provided that the charged affairs and the consular officers of Great Britain shall be at liberty to choose their own employees, and that British subjects shall be free to commit their affairs to the management of any persons whom they may appoint as their broker, factor, or agent. Nor, says the treaty, shall such British subjects be restrained.
Okay, let's hold up right here. Why is the United States of America pointing this out? Here's why. They're trying to tell you about who. Who gets to choose who's on the list. So the United States of America knows all about these treaties, and they're using it to their advantage. Because France is forcing them to come up with a list. The United States of America don't want to come up with the list. Why don't the United States want to come up with the list? Because then they will have to recognize who's a Moorish protege. So the United States of America wants to pretend as if Moors don't exist at all. France is forcing them to come up with a list, which means now the United States of America got to say, okay, Moor, you're on our protege list. They don't want to refer to us as being Moors, and France is forcing them to come up with a Moorish protege list. The United States of America is like, we don't want to refer to them as Moors. The Moors are all dead at sea under Admiralty law. And France is saying, no, they're not. Come up with the list, man. And that's why the United States keeps talking about who they get to choose. Because they really don't want to choose nobody. That must be understood. Let's continue.
Restrained in their choice of persons to act in such capacities. The Spanish treaty provides that the charged affairs or consular general may choose his interpreters and servants from amongst the Muslim subjects or amongst those of any other country.
Stop. Now they just referred to Moors as a totally different name again. Okay, here we go. Now they just refer to you as the Muslim men. Muslim men are who? That are subjects. They got all kind of names for us. Let's continue.
That other consular officers may name employees, either Mussulmans or subjects of another country, and that Spanish merchants may put their affairs into the hands of brokers or agents appointed by themselves, and they shall not be interfered with, nor shall obstacles be raised to the free choice of the persons to fulfill this charge. It would therefore seem that the choice of the proteges of the United States in Morocco rests by right of treaty ultimately with this government.
Stop. Look what the United States just admitted on the record. This is what young Moors have to catch. All Moors have to catch this, especially young Moors who are coming into the movement. Listen what the United States admits. The United States, it would therefore seem that the choice of the proteges of the United States in Morocco, that the United States in Morocco, rests on what? By right of treaty. So the United States is only in Morocco by what? The right of a treaty. So therefore they need to keep the Moors in a shallow grave, because if the Moors wake up and start to now function as governments, we get to now hold the United States to their obligations of said treaties. Let's continue.
Such appears to be the view which this department has always taken of the Convention of 1880, and which has been the basis of its action in carrying out the provisions of that convention. The question of the choice of proteges is, however, in the view of this government, but a phase of the larger question involved in the establishment of French and Spanish control over separate portions of Morocco. On the subject of the French protectorate, this government has therefore expressed itself as being in favor of the reforms which France contemplated introducing into Morocco in accordance with the stipulations of the Franco-Moroccan Treaty of March 30, 1912, on the understanding that provision be made for the preservation of American interests and rights in Morocco, commercial or otherwise, which are at present safeguarded by the existing treaties with that country.
Stop. You see, they just admitted again, young ones. Listen. Okay, let's just start here. The stipulations of the Franco-Moroccan Treaty of March 30 of 1920, right? So that's the Treaty of Fez, 1912. On the understanding that provisions be made for the preservation of the American interest and rights in Morocco. America's where? In Morocco. So why are Moors call themselves Americans? If America is in Morocco, Morocco is the Aboriginal name, not American. Because America is the other party. Let's continue.
Where am I? The more important of those interests and rights it is proper now to enumerate. In the first place, attention may be drawn to the right of aliens to hold land in the Sharifian Empire.
Stop. Let's point this out real quick. Who are the aliens? Time out, start to get a sentence. In the first place, this is the United States talking. In the first place, attention may be drawn to the right of aliens to hold land in the Sharifian Empire. What's the Sharifian Empire? Morocco. So who are these aliens they're talking about? You know who the aliens are? United States of America. The citizens of the United States are the aliens in Morocco. This is what the United States is referring to themselves as aliens. Why? Because they're foreign in Morocco. Let's continue.
This right appears now to be based upon the provisions of the Madrid Convention and the Algeciras Act. With a view to carry out Article 60 of the Algeciras Act, the Sultan's foreign minister on December 5, 1912, sent to the diplomatic corps at Tangier a set of regulations classifying the public domain of the empire and defining inalienable property and alienable property.
Stop. This is very important, Morris. Listen. Listen. In the first place, attention may be drawn to the right of aliens to hold land. Where are they getting this word hold land? That's the Treaty of Madrid, Article 11, that said the Sultan gave the citizens of the United States of America permission to hold property in Morocco. That's why they say hold land. In the Sharifian Empire, this right appears now to be based upon the provisions of the Madrid Convention and the Algeciras Act, with a view to carry out Article 60 of the Algeciras Act. What did we learn about Article 60? What did we learn about Article 60 of the Algeciras Act? That was the Kadhi. Remember we were talking about the Kadhi, C-A-D-I. That's Article 60 and Article 61. What's the responsibility of the Kadhi? To create taxes and revenue on behalf of Morocco. Now the United States is talking about this in 1914. Keep that in mind. They know exactly who the Kadhi is. That's why they put the Kadhi in the Black's Law Dictionary. Moors must understand what's happening right now. Now they're going to keep talking about this Kadhi. You're going to see in just a minute. Okay? Let's continue.
These regulations also laid down certain rules to govern the sale of the latter class of property to foreigners. It is understood that these regulations are not entirely consistent with the provisions on the subject of land ownership in the Act of Algeciras and the Convention of Madrid.
Stop. Okay. In class 41, The first thing France opened up when they started sending correspondence to the United States, the first thing they wanted to talk about was what? Moors. Second thing they wanted to talk about was what? Consular court. Now they're still talking about Moors. Now they're talking about what? Land. They're talking about the estate. So you see what France did first? First, France came over to secure what? The people, because the people is the state. The nationals are the state. We are the trust. We are the sacred trust. The people is the sacred trust. Then France started talking about consular court. Now they're talking about now what? The estate. You see the order they're doing it in? Let's continue. Stop. Sorry. I have to point this out. Look what the United States pointed out. They're pointing out what? Regulations classifying the public domain of the empire and defining inalienable property. What's inalienable property? That's the property that belongs to the Moors. Inalienable property. Okay? Now watch this word. This is the United States talking. And alienable properties. Well, what's alienable property? That's the property of the aliens who are holding deeds and what they call warranty deeds in Morocco, the Sharifan Empire. They have alienable property. Because why is it alienable? Because it can be liened. Why is this inalienable? Because this right here belongs to the sovereign people. This right here is property that's held in the name of what's called a deed. This United States defining this. Moors must understand that. The Kadhi must understand this. That the United States is making distinctions on what properties are listed under. That must be understood. Let's continue.
Regulations also lay down certain rules to govern the sale of the latter class of property to foreigners. It is understood that these regulations are not entirely consistent with the provisions on the subject of land ownership in the Act of Algeciras and the Convention of Madrid. Under Article 11 of the Madrid Convention, the right of all foreigners to hold property anywhere within the empire is recognized, and but the purchase of property must take place with the previous consent of the government. By Article 60 of the Algeciras Act, this right was confirmed, and it was further provided that within a radius of 10 kilometers around the open ports and within 2 kilometers around certain other towns, land might be acquired by foreigners without the previous consent of the Moorish government. The proposed regulations define inalienable property to include Guish lands, the seashores, habus or mosque properties, tribal lands, forest land, desert, uncultivated or ownerless lands, or bearing land, and as cheated property.
Stop. Okay. So you see the United States is pointing out distinctions of different classifications of land. Why is the United States pointing this out? Because France is coming over making a claim to the treaties. The United States is concerned and panicking. Is France going to try to now take away our deeds? Why? Because the United States of America hadn't been keeping up with the proper ledgers as it relates to deeds. They didn't want to play the game of the 1906 Act of Algeciras to allow the Kadhi to come over and start taxing them, so they tried to act like all their deeds now wasn't in proper order. So now they're trying to now classify what are these different classifications of property. What are they doing? Stalling, denying, defending, not allowing the Kadhi to come in and examine their paperwork as it relates to deeds. You're going to learn a little bit more about that here shortly, okay? But this is what's happening. The United States is making designations. What's another word they're just pointing out that Moors love to talk about? Listen. Exceeded property. Moors are always talking about estate and hypothecation. Well, that's true, Moors. The United States knows they exceeded our properties. But guess what? How do Moors get their exceeded property back? There's only one way to get it back. You got to come back to the treaties. Article 15 of Treaty Madrid. You must choose to submit to the empire, all the laws of the empire. That means come back to a Moroccan government, and the only Moroccan government is one through a state. Let's continue.
The department is advised that practically all of the land within the 10-kilometer zones, especially at Tangier, is either Gouache land or seashore. Consequently, there would appear to be little or no land lying within the 10-kilometer zones, which may be subject to private ownership without the consent of the Moorish government.
Stop. The United States knows they need the consent of the Moorish government when it comes to them holding land and when it comes to them transferring any deeds to another foreigner. Don't let them fool you. They know that their deeds have to be overseen by a Moorish government. Now, let me ask you a question. Did it say Moorish American government? It says Moorish government. Keep it simple. Let's continue.
Moreover, while in one paragraph the regulations recognize the fact that under Article 60 of the Act of Algeciras, no authorization is necessary for the sale of lands within certain zones. In the next paragraph, the regulations provide that the Kadhi will approve no sale made to a foreigner unless the authorization, according to the regulations, has been granted by the Magazin. It would seem, therefore, that if the regulations are correctly understood, an interpretation has been given to Article 60, which its terms would not ordinarily bear.
Stop. So right here, the United States of America points out the Kadhi specifically. They know exactly who the Kadhi is, and they understand the Kadhi's functionality. Who is the Kadhi? Let me tell you who the Kadhi is, layman's terms. The Kadhi can be compared to the chairman of the Federal Reserve. That's how powerful the Kadhi is. The Kadhi, in comparison, is as powerful or more powerful than the chairman of the Federal Reserve. As a matter of fact, the chairman of the Federal Reserve is subordinate to the Kadhi because the chairman of the Federal Reserve is in the jurisdiction of the United States because the Federal Reserve is a subsidiary of the United States based upon the Act. What Act? The Federal Reserve of 1913 was created by the United States, which makes it a subsidiary of the United States, and anything the United States creates is subordinate to Moroccan law. So therefore, the chairman of the Federal Reserve is subordinate to the Kadhi of a Moorish government. Let's continue.
It would seem, therefore, that the regulations are correctly understood. An interpretation has been given to Article 60, which its terms would not ordinarily bear. By the same regulations, the Moroccan government reserves the right to annul or to revise any deeds of so-called inalienable property, which may have been given prior to the date of the regulations.
Stop. Okay, right here. Now they refer to the regulations of what? Moroccan government. Moorish government, Moroccan government. Did it say Moroccan American government? Keep it simple, Moors. Moroccan government. Let's continue.
The department is advised that much of the Gouache and seashore property, as well as other lands situated within the zones above mentioned, has long been held by private individuals under deeds legally obtained with the authorization of the responsible agents of the Magazin.
Okay, stop right there. So the United States of America is pointing out what? This is the United States talking. Keep that in mind. We're going to get to France next. They call what? The inalienable, so-called inalienable property. Why are they saying so-called inalienable property? They're trying to say the Moors don't exist no more. Moors are dead at sea because the United States of America exceeded all the property, so there's no such thing as inalienable property. That's why they call it so-called. because the Moors haven't made a proper claim to their property. So all the property now is in the trust in the hands of the administrators of the United States. That's what they're trying to say right there. That's why they called it so-called. Let's continue.
In view of this circumstance, it is difficult to believe that it is the intention of the Moroccan government to consider these regulations as retroactive in their operation and as thereby divesting or giving opportunity to divest rights in land legally acquired and officially confirmed by the Moxim's agents. The proposed regulations, as understood by the department, further provide in effect that no transfer of land will be authorized until the different Moorish intermediaries have stated that no government rights are infringed. This provision probably has in view the carrying out of that part of Article 60 of the Algeciras Act, which stipulates that before authorizing the execution of deeds transferring property, the Kadhi will have to satisfy himself of the validity of the title in conformity with the Mohammedan law. The department is, however, advised that the records of land titles in Morocco...
Stop. Let's pause right there for a second. This is important to understand what's happening here. The United States is pointing out that they know that the Kadhi gets to oversee the transfer of any foreigner's deeds, right? But guess what they're talking about who really oversees the Kadhi? Look what they say. Moors intermediaries. So who has the power over the Kadhi? Moorish intermediaries, which is the Moorish governments, the Consul. When Moors come back in this proper statehood, we can have Moorish intermediaries. Why is this important to understand? Because the United States is concerned about Moors. They're concerned about what? Consular court. They're concerned about what? The real estate. That's what they're concerned about. Now they're concerned about what? What is the function of the Kadhi? Taxes. The United States hates paying taxes to any other side. Let's continue.
The department is, however, advised that the records of land titles in Morocco are very incomplete, and that this provision of the regulations may be used to delay indefinitely transfers of property in which the Moorish government has in fact no legal or equitable rights.
Stop. You see what they just said? This United States, they love to stall, deny, and defend as long as they can. What are they trying to say? Well, I know the Kadhi gets to oversee the deeds, but right now our deeds, our paperwork is not all straightened out just yet. So if you want to come in and perform some type of investigation, some type of an audit to take a look at our deeds, well, it's not ready yet. Give us some time. But it might be indefinite. Listen. The department is, however, advised that the records of land titles in Morocco are very incomplete. So wait a minute. They're saying the land titles are in Morocco. Did they say United States? No. Did they say United States of America? No. The United States knows they're in Morocco, young Moors. They're in Morocco, are very incomplete. What's incomplete? The land titles. What's the land titles? The deeds. Are very incomplete, and that this provision of the regulation may be used to delay indefinitely transfers of property in which the Moorish government has in fact no legal or equitable right. So you got to understand there's a duality going on. The United States don't have their paperwork together. At the same time, they're saying, man, the Moors could just hold up the entire process of transferring the deeds to the next foreigner because there's no timeline involved in terms of how long the Kadhi can hold up the process. See, there was never no Moroccan law that said the Kadhi can hold up for what, 30 days, 60 days, 365 days. There's no specific language that talks about how long the Kadhi can hold up the transfer, so the United States is concerned about that. So what's happening? There's a duality here. The United States is saying, well, my paperwork's not right. But at the same time, if it was right, then the Kadhi could come in and just hold up everything. So the United States is stuck between a rock and a hard place. What's important to understand here? The United States know they're subordinate to the Kadhi. And the Kadhi is subordinate to what? Moorish governments. Let's continue.
As a further restriction upon the right of land ownership, it is reported that notwithstanding the provisions of Article 60 of the Algeciras Act respecting the acquisition of land within stated zones around the open ports and certain other towns, the Sultan, about a year ago, issued 2 decrees imposing military servitudes upon land situated within a radius of 250 meters around towns and fortified quarters within certain enumerated districts.
Okay, what's happening? The United States is making some allegations, saying the Sultan came in and started now surrounding the so-called land that the foreigners were supposed to have access to. What's happening? The Sultan wants his taxes. The colonists are always slow to write the check. Let's continue.
It appears that certain habus or mosque properties are alleged to have been irregularly disposed of in the past to persons subject to foreign jurisdiction who hold these properties either without regular title thereto or by virtue of doubtful contracts. The Algeciras Conference took formal note of this situation and by Article 63 of the Algeciras Act charged the diplomatic body at Tangier to solve these questions equitably in accord with the special commissioner whom His Sharifian Majesty may be pleased to designate to that effect. This stipulation does not appear to have been carried out. On the contrary, the department is informed that the Sultan has communicated to the diplomatic corps a circular proposing measures for the recovery of such properties. In these circumstances, it would seem that titles to land already acquired and the right to make acquisitions in the future are being called into question and placed on an uncertain basis. This government is therefore desirous of some assurance that the vested rights of its citizens and protégés in property in Morocco will be respected, and to that end will be promptly confirmed by the Moroccan government, and that existing treaty rights respecting the purchase and sale of land within the empire will be protected and preserved.
Stop. Now keep in mind, in Class 41, France was trying to get the United States to agree to what? Giving up what's called extraterritorial jurisdiction in Morocco, and to now ratify and promulgate the Treaty of Fez of 1912. That's what this argument is all about. The United States talking. They're giving reasons as to, they're saying, hey man, we got a checklist of things that need to be taken care of first before we ratify the Treaty of Fez of 1912. The United States is outlining some issues they're having. Okay? But what are they saying right here? In these circumstances, we've seen that titles to land already acquired and the right to make acquisitions in the future are being called into question and placed on an uncertain basis. What's happening? They're saying the Sultan and the Moorish governments are holding up the citizens from being able to transfer their deeds. Keeping in mind at the same time, the United States of America saying Moorish governments don't have a right to even say nothing about it. So they're saying one thing and saying another, right? What are they saying? They're admitting that they don't have any respect for the Kadhi. At the same time, they must respect the Kadhi. Let's continue right here. Watch this. This government is therefore desirous of some assurance. What do they want assurance of? That the citizens get to hold on to the properties, even though they didn't follow the instructions of the treaty, they just want to hold the properties anyway. Assurance that the vested rights of its citizens and protégés, let's stop right here. Look what the United States did. They made distinctions. Listen. Some assurances that the vested rights of its citizens and protégés. Wait a minute. of its citizens and proteges. See, even the United States makes a distinction between who their citizens are versus who their slaves are, who their protected parties are, who their coloreds are. They're not conflating the two. They're making distinctions more. Listen to what I'm saying. They don't really consider these proteges as being citizens. They're the protected property of the citizens. This is the United States talking. You got to pay attention more. The citizens, i.e. the Americans, don't consider proteges as being Americans. That's what you got to catch here. This is that choose between. They're making a distinction between these two classifications. This is what Moors got to understand. But Moors are saying that they are the citizens of the United States. Moors are saying they're Moorish Americans. And even the United States is saying, no, you're not. Let's continue.
In these circumstances, it would seem that titles to land already acquired and the rights to make acquisitions in the future are being called into question and placed on an uncertain basis. This government is therefore desirous of some assurance that the vested rights of its citizens and proteges in property in Morocco will be respected, and to that end will be promptly confirmed by the Moroccan government, and that existing treaty rights respecting the purchase and sale of land within the empire will be protected and preserved.
Okay, so wait, the United States of America is admitting what? That their what? Their properties are where? Are within the empire. And they want their properties to be what? Protected and preserved. By what? The treaties. Why? Because the United States of America and its citizens are aliens, refugees in Morocco. And what secures their rights to stay in Morocco? Treaties. And they're talking about treaties right now. Moors have to start learning how to enforce your treaties. You notice they're not talking about a constitution? Because all states must have a constitution. Those two cancel each other out. You go from the constitution, you put this down, now you pick up what? Treaties, treaties. You pick up the treaties more, the treaties. They're talking about enforcing treaties. Let's continue.
In the second place, the department ventures to mention the subject of trade discriminations practiced by the authorities in Morocco. Complaints, apparently well-founded, have reached this government that customs duties have been imposed arbitrarily and without uniformity.
Stop. Now they're talking about what? Trade, commerce at the ports, customs. That's what we're going to learn a little bit about now. Wait, time out. Let's look at the board. So first, France comes over, the United States starts talking about what? Moors, branded as proteges and subjects. First thing they want to talk about. Second thing they started talking about in class 41 was jurisdiction of consular court, right? They're checking boxes. France and the United States is checking boxes. Then they start talking about what? Land deeds. That's what they just started talking about, right? Now they're going into what? Trade and commerce at ports and customs. We're going to learn about that. They're checking boxes more. But the first thing they had to start off talking about was what? Moors. Because without the Moors, there's nothing for them to hold on to. Because the treaty is a bilateral treaty amongst who? Moors and the Americans of the United States. And without the Moors, there's no citizens of the United States of America without Moors. Moors is the beginning and the end to everything. That's why they keep starting off talking about the Moors. And then they started talking about consular court. Why? Because they want to keep these Moors in check and in fear and inferior to the colonist courts. That's how you keep Moors in check. You make them scared of law enforcement. Then they went right into the money. So what are they talking about? This controls money. This controls money. And obviously this controls money. But there is none of this without the Moors. Because the Moors is the money. It's the movable money. The people, the Moors is the money. Without the Moors, there's none of this. You got to understand what they're doing. They're very strategic in what they're doing. Secure the Moors. Whoever controls the Moors controls Consular Court. Whoever controls Consular Court now gets to control the land, because the courts control the movement of the land. Courts are the gatekeepers. Then you get to control the trade and commerce, because that's what comes last. The wealth, the prosperity, the prosperity comes last. And that's what they're doing right now, securing the bag. Let's continue. Let's start here.
In the second place, the department ventures to mention the subject of trade discriminations practiced by the authorities in Morocco. Complaints, apparently well-founded, have reached this government that customs duties have been imposed arbitrarily and without uniformity, that unreasonable export duties or surcharges have been collected, and that free and open competition in bidding for the construction of public works or the furnishing of supplies for the government have been denied. It is reported that customs duties on the imports of the Vacuum Oil Company vary for different ports of entry and for different countries of origin, thus in practical effect working a discrimination between importers at the same or different ports. For example, it is stated that in the recent past, the customs duty has varied from 5.50 francs to 6.50 or 7 francs per case. The department is also informed that in 1911, exporters of olive oil in barrels from Mogador, Morocco to New York were arbitrarily made to pay 14 pesetas surcharge as tare on the barrels, regardless of the offer and desire of the exporter or his agent to empty a sample barrel for the purpose of determining the exact tare for the shipment.
Okay, so just for clarity, what are we talking about right now? Talking about trade and commerce at ports, customs. They're concerned about the taxation that's taking place at the ports. So they're checking the boxes. Treaties are about what? Amity and commerce. But there's no treaty without the Moors. Let's continue.
It is understood that Articles 105 to 110, inclusive of the Algeciras Act, require free and open competition without preference of nationality in bidding on proposals for public works and supplies for the Moroccan government. The department is advised, however, that specific proposals are not always prepared so that real competition is possible. It is stated, for example, that the specifications do not always disclose the rate of duty on materials and machinery and tools, so that distant bidders unacquainted with local conditions are placed at a great disadvantage in formulating bids. It is understood also that the opportunity of foreign contractors to take part in competitive bidding is minimized by the method of dividing large government contracts into allotments too small to attract any but nearby contractors.
Okay, let's stop right there. What's happening here in this section here? Now the United States is worried about what? How can they even get contracts of the ports and customs? It's about trade. How do states make money? Imports, exports. They make money in the exports by charging people fees for their products. But they also make money on imports because they get to charge a tariff, a tax for it to come into their state. But also at the same time, the United States is concerned about getting contracts all together. You have to understand what's happening. They're checking the boxes. Why is this important to understand? Guess who's not checking these boxes? Moors. Everybody's checking these boxes but the Moors. Everybody's getting paid off the Moors. But when Moors come back and choose the entire submission of the laws of the Empire of Morocco, and guess what? Then we're being enforced our own treaties. When we enforce the treaties, we bring out the Kadhi, we bring out Consular, we start enforcing our own trade and commerce with other states around the world. We control the coastal lines. We control the seaports. And after that, what do? We start checking boxes. We check boxes. But we can't check boxes if we're stateless. Let's continue.
As the main purpose of the United States in participating in the Algeciras Conference and in the adoption of the act resulting therefrom was to preserve and increase its commerce in Morocco, this government desires equal opportunities for American commercial interests not only to maintain their present standing in Morocco, but also to share in the country's commercial development.
Stop. Do you see the distinction that the United States of America keeps making? They say American commercial is distinctive from what? Morocco. See, they understand that choose between. Young boys have to understand you're not Americans. Because the United States of America knows exactly who the Americans are. And they know exactly who the more Moroccans are. Moors have to learn how to make the distinction as well. Let's continue.
In the third place, the department is advised that a commission composed entirely of French nationals has been appointed for the liquidation of outstanding claims against the Maxim. Notice of this commission and of the date for presentation of claims has been communicated to this government and to American citizens and protégés in Morocco.
Stop. Young Moors. The United States continues to make distinctions. Listen, they make a distinction between American citizens and who? And who? And protégés in Morocco. Protégés are not Americans. Americans are Americans. Protégés are Moors. The United States is trying to tell you this.
The department is not at present advised as to the exact amount of the claims so far presented, but it is believed that the sum approximates $150,000. It is also understood that certain awards made by the Claims Commission, which sat in 1910 for the purpose of considering the claims of aliens against the Maxim, have not as yet been fully paid.
Stop. Okay, right here. Okay. Right here. Okay, let's start right here. It is also understood that certain awards made by the Claims Commission, which sat in 1910 for the purpose of considering the claims of aliens against the Maxim. What's the Maxim? That's Moroccan governments. So who's the aliens? The foreigners in Morocco, i.e. the citizens of the United States, i.e. the Americans. The Americans are the aliens. This is the United States talking. So why would Moors want to call themselves Americans when the Americans call themselves the aliens? This is the United States talking. Let's continue.
This government, therefore, is desirous that the awards of the Commission of 1910 be duly paid to the American claimants, and that some assurance be given that the awards of the present Commission will be paid within a certain reasonable period.
Okay, so what's happening? The United States is trying to make sure they tie up some loose ends before they totally commit to the Treaty Affairs of 1912. See, they're negotiating. Keep in mind now, the Sultan signed the Treaty Affairs in 1912 along with France. But yet the United States still thinks they can negotiate even though the Sultan already signed the treaty. The United States does not have a position here to really negotiate. But I commend them for trying to negotiate. You'll learn more about how these negotiations go. But why am I pointing this out? This is a tactic that the United States always uses. They will try to find a way to secure what they think are their rights, even though their rights are contrary to a treaty. Let's continue.
Finally, it is perhaps proper to mention the case of Jacob Benatul, an American citizen who has for some years been engaged in litigation before the Moorish courts.
Stop. Moorish courts. Let's read that sentence. Finally, the United States is wrapping it up. Finally, they've been talking for a long time in this letter. Finally, it is perhaps proper to mention the case of Jacob Benatul, an American citizen who has for some years been engaged in litigation before the Moorish courts. Wait. Right now, we're in the year 1914, according to this letter, in 1914. So in 1914, there were some Moorish courts. You know what those Moorish courts were? In Tangier. Wait a minute. I thought they said there was no more Moorish courts left. Oh, there's no more Moorish courts left where? In the Western Empire, northwest of Mexico. You had to go back to Madrid for a Moorish court. But wait, what's my point? The United States was perfectly aware there were Moorish courts, consular courts in Tangier. Wait, then why didn't they let the Moors of northwest of Mexico utilize the Moorish courts in Tangier? You know why the Moors couldn't use the Moorish courts in Tangier? Because the Moors were branded as Negro, black, and colored. They wasn't Moors on the record. They were branded as what? African Americans, Indians, anything but Moor. So a Moor can't use a Moorish court for consular court if they're calling themselves anything other than Moor. However, there were Moors around at that time in 1914, and guess what the Moors would call themselves? Moorish Americans. That's the truth. So if a Moor claim to be a citizen of the United States of America, guess what you just did? You consented to the jurisdiction of the United States of America, which means you can't use the Moorish courts because you're saying you're a citizen of the United States. You can't claim to be both sides of the contract. You must understand what's happening right here. The United States is admitting there was Moorish courts in 1914. Moors were unaware of this. Why? Because we were saying we were citizens of the United States. And we were saying that this Constitution of the United States of America was our Constitution. That's the truth. It never has been our Constitution, and it never will be our Constitution, because if you're claiming this as your Constitution as a Moor, that means you have waived your rights to a Moorish court. Because Moorish courts are for who? Moors in Morocco, and not proteges in America. That must be understood, Moors. We got to start telling the truth. We got to be honest with ourselves. Moors got pain. They just want to fix this. How will they get to a Moorish court if they're not a Moor in Morocco? Let's continue.
Finally, it is perhaps proper to mention the case of Jacob Benatul, an American citizen who has for some years been engaged in litigation before the Moorish courts in the manner provided in the Treaty of Madrid in an effort to secure the restoration of a strip of land said to have been arbitrarily taken and used for a highway. It appears that the property of Benatul bordered on a roadway, and that certain persons of foreign nationality, including Frenchmen and Spaniards who owned land on the opposite side of the road, erected buildings beyond their property lines, and therefore caused the roadway to encroach upon the land owned by Benatul. In the course of the litigation, Benatul obtained a judgment in his favor by the XLIII, which on appeal has provided by treaty as provided by treaty, was confirmed by the Sultan's foreign minister. Thereupon, the Consul General of the United States, according to custom, requested the Moorish authorities to enforce the judgment.
Stop. So the United States, one of their citizens, was utilizing consular court in Tangier because he was a citizen of the United States of America, enforcing the treaty of Article 20. When there's a dispute, you use what? Consular court. So the United States citizen is over in Tangier and got a favorable appeal from a Moorish government. This is what you got to understand. The United States already knows they're supposed to come to consular court when there's a dispute. That's what you got to take away from this right now. The United States is admitting consular court is the proper venue when a citizen has a dispute with Moors or with Moorish land. That's what Moors got to understand. Let's continue.
Oh, but they never acceded to the request. The only legal course then open to the American claimant was for him to sue upon the judgment in the consular courts of France, Spain, and the other countries whose nationals were concerned. It is doubtful whether such a course would have proved effective, inasmuch as it is understood that the defendants would, in the event of a decision adverse to themselves, have had the right to appeal to the superior home courts of their respective countries. As the expense involved in such proceedings was prohibitive to the American complainant, the department has long desired that this case, which has been a source of misunderstanding and diplomatic correspondence for many years, should be disposed of by a settlement between the two governments.
Okay, thank you. So what's happening here in this last part of the paragraph? The United States is pointing out that one of their citizens got a favorable appeal order from a Moroccan government. That the Moroccan government did not maintain that judgment and give the United States citizen his land. So then the United States citizen was considering now to go to consular courts of Spain, etc., looking for a court that will be more open to taking in a case where they're not biased. The Moroccan courts were being biased. Even though they had a judgment for the United States citizen, they still didn't uphold it. The citizen was still trying to get the land. There was no further action. So the United States is pointing out that that citizen just kind of gave up on the case. Even though they won the case, they still was not able to get their land. This is one of the things the Moors got to understand. The Moors cannot be belligerent when we come back into our Moor state governments. We must maintain equality at all times. We cannot turn around and do what's called reverse colonialism on the colonists. Everything we do must be fair and equitable. Keep it simple as relates to the treaties. Your consular courts should not be biased. Your consular judges should be all about the strict sense of contracts. That's what judges are supposed to do. Interpret the law and enforce the law regardless of who the parties are. Let's have fair courts, Moors. Let's continue.
The foregoing statement covers the more important matters under discussion between this government and that of Morocco. There are other matters which have given rise to diplomatic correspondence, but they may be reserved for future discussion, if need be. The present review embraces matters that touch the maintenance of American commercial interests in Morocco and the protection of the liberty and property of American citizens and protégés in that country, and it is for the purpose of removing any points of controversy in these particulars and bringing about an adjustment of them that this government, animated with a favorable disposition toward the reforms which the French protectorate is designed to assure, has addressed itself to an exposition of the questions as to which it desires to reach a definite understanding and settlement as a preliminary to or incident of the recognition in due and proper form of the fundamental change involved in the establishment of a foreign governmental regime in the Sharifian Empire.
Okay. All right. So the United States is referring to their own self as being what? A foreign governmental regime in the Sharifian Empire. What's Sharifian Empire? Morocco. But what are they really saying here? The United States is asking France, since France now is coming in as a vice sultan. France is who? France is a vice sultan at this time. They're dealing with who? The Americans, which are citizens of the United States. So the United States is asking France, since now you're the vice sultan, let's tie up some loose ends before we now ratify this Treaty of Affairs of 1912. That's what the United States is doing. But you must understand, the United States has been belligerent. They haven't been enforcing the treaties. They've been getting over on the treaties. And France is coming over and telling them, you're going to get back to the strict sense of treaties. The United States doesn't like that. So now they're trying to negotiate, even though their position is non-negotiable. Let's continue.
In conclusion, it may be proper to call attention to the situation of the American missionaries in Morocco. These missionaries have for years labored in this field, including the districts inhabited by the Berber tribes, and as the department is advised, have maintained and continue to maintain friendly and mutual satisfactory relations with the authorities of the country.
Stop. So right here, the United States recognizes the Berber tribes. Do you see that? Who are the Berber tribes? Those are the Amazigh people over in what they call North Africa, or what's commonly known as the Kingdom of Morocco. So even the United States recognizes the indigenous people of the Berber tribes, even though the word Berber is applied to the indigenous people because they're not Berber, because Berber means barbarian. Berber means vandals. This is where they get the word burglary. Burglary comes from Berber. So this is a derogatory term, but you must understand that even the United States recognizes who's the indigenous people of the land, the Berbers, even though they're misclassified. Let's continue.
They have expressed themselves as most appreciative of the courteous and kind treatment accorded to them by the French officials in Morocco. This government therefore ventures to express the earnest hope that in any reorganization of the government of the empire which may be contemplated or in progress, the rights and privileges of these missionaries may be carefully safeguarded and every facility be granted them for the prosecution of their worthy and benevolent task. All right.
So the United States finally stopped talking. All right. Now we're getting ready to see how France responds to all of this. The United States has been rambling for quite some time. Okay. Now this is the French ambassador to the Secretary of State. Keeping in mind now, we're now in April 22nd, 1914. When did this discussion start? January 1913. Now then, in April 1914, the United States of America is doing what? Stall, deny, and defend. It's been going on now for almost a year and a half. Correspondence going back and forth. They always stall, deny, and defend. Moore's got to understand that. How did Moore stop this? How did Moore stop the United States of America from stalling, denying, and defending? You know how you do it? It's called consular court. Consular court makes an order, and that's it. What are we learning from this? The United States of America will continuously negotiate while they're holding on to what it is that you know you rightfully deserve. That's rightfully yours. Do not get into long-term negotiations. You issue your orders from consular court, and that's it. It's final. Or it's without prejudice. Now to go to the ICJ. United States of America got a problem with it? No worries. Stick to the treaties. Go to the United Nations Charter, and the United States can now petition the Secretary General, or they can petition the ICJ if they don't like consular court's decision. That's how Moore stopped all this spinning. That's how Moore stopped all this stalling. Consular court. Let's continue.
French ambassador to the Secretary of State. French Embassy, Washington, April 22, 1914. Mr. Secretary of State, referring to the oral communications by which I made known to the Department of State the views of my government in respect to the remarks contained in Your Excellency's note of February 13 last about Morocco. I have the honor, in compliance with instructions I have received, to remind you of the high value we should attach to the United States government's relinquishing, together with its consular courts, its extraterritorial privileges in the French zone and the Sharifian Empire.
You see how France opens up? France goes right back to what? Talking about consular court. They went right back to talking about consular court. Why? She who controls the land controls its laws and its wealth. France is trying to control the land through the treaties. How do you control the land? Well, you control the land through statehood, but what controls the state? What guards the state? Judges. Law enforcement. Moroccan legislation. So France is coming right back to consular court point. Why? Because they can control the laws, then they control the land and its wealth. She who controls the laws controls its land and its wealth. Excuse me. She who controls the land controls its laws and its wealth. France is trying to control the land and trying to control the laws. And if they control both of those, they automatically get what? The wealth. They know that. What should Moors learn from this immediately? This is France going into. Moors need to start checking their own boxes. Moors should be just as concerned as France was. First thing Moors should be talking about is what? We're no longer Americans. We're not branded anymore. So check that box. You ain't a protege and a subject no more. Then you go right into what? Enforcing consular court, because now you come back to a Moroccan government. You ratified your state. You deposit your constitution, your treaties with the Secretary of the United Nations. You get right into jurisdiction of consular court and start issuing your orders. Because now you're controlling what? The land and the law. After you control the land and the law, you get right into commerce. That's what Moors have to take away from this. Let's continue.
Your Excellency's note above mentioned held out the prospect that the United States would accede to our request and record its accession in due and proper form, but pointed out a certain number of topics as to which favorable assurances were requested. As to the matter of form, my government wishes me to submit to Your Excellency the enclosed draft of declaration, which in its opinion fits the situation that is to be cleared. I am told that the declaration has already been signed by the Russian and Spanish governments and that other adhesions are forthcoming. As to the several points mentioned in Your Excellency's note, I may, as I have already done by word of mouth, assure you that the government of the Republic is quite ready to settle in the most friendly spirit the question of interest to the United States in Morocco that may still be pending.
Okay, so what is France? Is France talking? What did France say the United States is? Okay, United States is in Morocco. Listen, Moors. The United States being in Morocco is no secret. It's what you call an open secret. It's open knowledge to everyone around planet Earth that knows the truth. But it's a secret to those who don't know the truth. Moors must understand that the United States is not claiming to be Moors. They're not claiming to be Aboriginal. What are they claiming? They're claiming that Moors have failed to come back to the entire submission of the laws of the empire. So therefore, the United States gets to hold on to our vast estate until we check the boxes. Until then, they are going to continue to check the boxes because they're saying the Moors don't exist. Because Moors have failed to come back to treaty law. That's the truth. Let's continue.
As to the several points mentioned in Your Excellency's note, I may, as I have already done by word of mouth, assure you that the government of the Republic is quite ready to settle in the most friendly spirit the questions of interest to the United States in Morocco that may still be pending. Among these, that of the protégés naturally ceases to be of any practical importance to the powers that agree to recognize our new courts. The tertives tax being, besides, already paid by the foreigners.
Stop. Listen, Moors. So the other colonial powers in Europe are now agreeing to the Treaty of Fez of 1912. They're all now ratifying the Treaty of Fez of 1912, now admitting and consenting that now France is overseeing the Moroccan treaties. France and the other colonial powers of Europe are saying now about the Moors, because that's been the concern the whole time why the United States didn't want to sign the Treaty of Fez, because they're trying to figure out what's the status of these Moors. Can the United States hold on to these capitulatory Moors who have failed to come back to their own Moroccan government? What happens with these Moors? Guess what France tells the United States? Listen. Among these, that of the protégés naturally ceases to be of any practical importance to the powers that agree to recognize our new courts. What's happening? The other colonial powers didn't care about the protégés, the Moors. They was like, tell the United States, we ain't worried about the protégés. The protégés are the property of the Americans. Why did the other colonist countries think that way? Because the Moors had an obligation to come back. Remember, this is 1914, they're talking about this. The Treaty of Madrid came out in 1880. We're talking what? 34 years later, 1880 to now 1914? A whole generation gone by, and the Moors had failed to come back to their own Moroccan government. So the other colonial states is like, when the Moors get ready now to come back to their government, they'll do it. In the meantime, let's move forward, because we're going to get into this what? Trade and commerce. Let the Moors figure out what they're going to do about their own status. Let's continue.
As to the right of aliens to own real estate, it has not been restricted by any Sharifian regulations. All that has been done was to take a few urgent measures having relation to strategy or prompted by the necessity of checking speculation in land intended for public use.
Stop. So what is France doing? Going down the checklist. First they talk about the Moors. Now they jumped over to what? Real estate. You see what's happening? They're checking boxes because the United States had concerns. France is trying to check the box and let the United States know, hey, we recognize your concerns. The other signatory powers, colonial states, recognize your concern. Don't worry about the Moors. You keep them. Now let's start talking about your real estate. You get to keep your real estate. You're supposed to pay your taxes, though. But you can have your properties. Let's continue. The complaint.
The complaint of the Vacuum Oil Company against the customs treatment according to its products had not been brought by the party concerned or the representative of its country to the notice of any government which deems it its duty in this respect to recall that the treaties in force guarantee equal fiscal treatment to all the powers, and that they may be sure that nothing will be overlooked.
Stop. So we're now, what box they checking now? The oil company, right? Was talking about what? This trade and commerce. See, they're checking this box now. So what happened? First box they opened up with talking about Consular Court. France opened up with Consular Court, they checked the box. Then they said, okay, the other signatory powers in France are like, we don't care about the protégés, do what you want to do with them. Then they went right into the real estate. You get to hold your properties, but you owe taxes. Now they're talking about what? Trade and commerce at the ports. They're checking boxes. Let's continue.
Which deems it is its duty in this respect to recall that the treaties in force guarantee equal fiscal treatment to all the powers, and that they may be sure that nothing will be overlooked to let their nationals enjoy the full benefit of those advantages. My government indulges the hope that under the conditions I have just brought to mind, and in view of its firm intention to examine and settle in an entirely friendly way the few questions yet unsettled in which American citizens are interested, Your Excellency will kindly coincide in the views I have just had the honor to submit to you. Your acceptance of these propositions would be particularly gratifying to the government of the Republic, which would take it as fresh evidence of the traditional friendship existing between our two countries.
All right.
Be pleased to accept.
All right. So, as we're wrapping up, this is not the end of the reading. We'll pick this up in class 44. But what should we learn thus far? All France and America keeps talking about is who? Moors, who are branded as protégés and subjects. And everything that the Moors should be overseeing and governing, France and the United States of America are talking about consular courts, real estate, trade and commerce, because the Moors aren't talking about it. What should we learn from this? We have to learn how to now enforce our own treaties so we can get back our consular courts and our trade routes. In the meantime, the colonies are going to continuously take care of their own states, their own foreign states, their own alien states, because the Moors have failed to make their own claim. So, as we wrap this up, I continue to let the Moors know the answers to the test is studying international law. This is an international law document because it's a correspondence between two international states. You got to recognize Moors. Moors keep talking about enforce the Constitution. You have to understand that when you keep talking about enforce the Constitution, you're admitting that you don't have your own Constitution. You're admitting that you're what? A protege. You're admitting that you're a subject because you don't have your own Constitution. When Moors ratify their own Constitution and come back to statehood, and they ratify all the treaties, declarations, and conventions, United Nations Charter, then they turn around and take all those treaties and now add that a part of your law as one. Then you deposit that with the United Nations Charter. Those are the instructions, the Secretary. Now you can enforce your proper status as being a Moor of Morocco, not American. Then you can immediately start to do what? Enforce consular court. And consular court is going to enforce what happens in our land. And consular court is going to enforce trade and commerce. That must be understood. I am back. Islam.